Okay, I think we're gonna get started so that we don't waste too much time. So welcome everyone. Thank you so much for joining us today. We are happy to have you here with us. As you know, this is our protecting our IP session with Uduak Oduok, and we're happy to be having this session today just to share a bit more about what we can do as an industry to ensure that we are protecting our creative work and making sure that it's working for us maximally as much as we can. So I'm just gonna talk a little bit about our organization, Bias in African Fashion. Um, I know we are a new organization, so many of you may not be familiar with us. So I'm gonna just talk a bit about the organization briefly, introduce our speaker, and then I'm gonna open the floor up to her to take us into the presentation. And then following her presentation, there'll be some time for Q&A. And we're hoping to round up in the next hour so that we can let you get on with the rest of your day. So about bias in African fashion. So Bias in African Fashion is a new organization, just about a year old. And I didn't introduce myself. My name is Udochi, and I am one of the co-founders of Bias in African Fashion. And my other co-founder, Papa Oyeyemi, is also on the line. I'm going to ask him to just wave so that everybody can see who he is. So by Papa. So bias in African fashion, as I'm saying was saying is that we are a platform that is looking to identify and eliminate bias in Africa's fashion segment. And there are several ways that we're looking to do this. One is that we really want to just start to generate conversation around issues of bias and prejudice so that we can start understanding where the issues may be. Because we believe that if we don't really have a real understanding of what the problems are, then we won't really know where we should plug in to do work. We also want to work with industry players to help them understand how they can be more open and reduce any bias and prejudice in their work. There's so many great organizations in the African fashion space who are already doing work right now. And we want to work with them to help them do better those things that they're already doing. We also want to create opportunities for entry into the fashion sector and to reduce any barriers that might be in the ways of individuals from really pursuing careers in the industry. And lastly, we want to foster an atmosphere of collaboration and knowledge sharing among the industry. We really believe that it's through working together that we can achieve the goals that we want and really build a strong and vibrant fashion sector in Africa. And on that note of collaboration, we have been putting together a great team of individuals, fashion sector individuals across various parts of Africa and also the diaspora. So we have our advisory council made up of 3 individuals from different parts of the continent and the diaspora. And we also have a champions council that we've been putting together that represents, again, different segments or regions of Africa, because as I've stated before, our goal really is to put together a team that represents different parts of the continent and also different sectors of fashion, so that we can have a full discussion that is representative of all as we look to take on our work. So that's bias in African fashion in short. I hope that as you get to maybe engage with us more, that you'll be willing to work with us and also attend more of our sessions. And with that, I'm gonna go into our presenter for today as we look to start the main presentation for today. So I'm just gonna read the bio of Ms. Uduak, if you would permit me. So Ms. Uduak Oduok is a fashion and entertainment lawyer at Fashion Int law firm, where she helps creatives and entrepreneurs increase their revenue and reach, all while reducing or avoiding risk. She has litigated a variety of issues in California courts, and represented and counseled clients on matters ranging from contract disputes, copyright and trademark infringement claims, and licensing to other diverse fashion and entertainment industry agreements. Uduak brings a unique background to problem-solving legal issues for her clients. She's a former fashion model with over 2 decades of hands-on fashion and entertainment industry experience. She's also an adjunct professor who teaches social media law and ethics and social media data analytics at the Academy of Arts of, at the Academy of Arts University in San Francisco. Furthermore, in 2019, she crafted, inaugurated, and taught the first ever fashion law course at California State University, Sacramento. For her work in the field of law and the fashion and entertainment industry, she has earned numerous nominations and recognitions, including an award from the American University Washington College of Law for her legal impact in the field of intellectual property in Africa. She's a routinely invited speaker who has spoken at numerous organizations, including the Fashion Law Institute, Wharton School of Business, South by Southwest, Levi's, Pechuakua, and the National Association of Women Business Owners. So we're so pleased to have Ms. Uduak here with us today. As the brief bio shows, she's very experienced and comes highly recommended by many in the industry. So with that, I am going to turn it over to Uduak to take us further in our session today.
Thank you, everyone. Udochi, thank you so much. I go by Miss Uduak. Different places know me by different things, so it's just easier for the branding to go by Miss Uduak. So thank you for having me here. I'm excited to be here, and I think that the topic or the background history behind your organization ties well into what I'm going to talk about and the kind of work I've done in this space. So I'll take you all 15 years back. I was very busy attorney. I'm now 20 years practicing law, but busy attorney doing a lot of trial work, and any given day, 3 to 5 times a week in court doing trials. However, I was also modeling. And one of the things that would happen was when I was in mainstream modeling here in the US, at New York Fashion Week or locally in other secondary markets, what I would find was everybody said, "You're stunning, you're beautiful, you're this, you're that. Oh my gosh, can I use you for this? Can I use you for that?" But once I got into my local community, I would hear all the stereotypes about Africans. Then I started to make an observation of how we were presented in media, particularly in fashion. And what I saw were two things. Number one, as Africans, I'm of African heritage, specifically Nigerian. And one of the things I started to see was that Africans historically have always been having others, particularly the West, write our narratives, number one. And number two, not only write our narratives, they take the clothes off us. We are always naked when they talk about us. So it became imperative to put the clothes back on us as part of seizing and owning and claiming that narrative. The other thing I noticed was that in fashion, yes, I was part of this, model on the marketing and promotions. And when you talk about the business framework for any fashion business or any business, but as part of marketing that product, there are different medium or channels you can use, and one of which is to hire influencers or models to help you get your product out there in the marketplace. So as a model, helping to promote and brand the designer's products and services, what I found often was there was a polarity of the identity of the African model. We either had to be super dark, which was the Alek Wek type of look, which is beautiful, but that was hard contrast and juxtaposition with Leah Kebede type of look or Iman type of look. There was no in between, no middle ground. And if you are the other look in terms of Alekwek look, you had to be bald. No question about it, because for some reason we couldn't have, grow hair like everybody else. It had to be bald headed, etc. So I started to look at all these things and said, there is bias in this industry, and I'm not comfortable as a woman going on the runway, being told I'm beautiful, etc. But then when I go into my daily life, whether in the courtroom, boardroom, or outside of, someone is telling me that this is who I am. I refuse that. I know who I am, and it's not some weird concept of being in a jungle or some weird concept of walking around with a rotunda, a stomach and flat butts in some wild wilderness. Because at the time, we still had the geographic or whatever that channel is. Why am I forgetting it now? That would constantly have this, this documentaries that presented us a certain way. So I said, how can I be a part of change? I'm a member of the press. I had an undergrad degree in communications. How do I begin to change this? I thought I didn't have the time. So I contacted someone at the time, a fellow African who had a blog. It was just emerging. All of this blog stuff was just emerging. And I said, you know what? I'm going to do the research. Please publish and take it and run with it. And I did the research. It took me a long time. I wrote an extensive, comprehensive article on how we can change that and the role and significance of the African model, titled Demystifying the African Model, the Exoticness of the African Model. I presented it to her, but she wasn't interested in taking it on. So I said, oh, who's going to do it if I don't do it? But I just had too much on my plate already. So what I decided to do was to train myself to see if I could have the consistency and discipline to actually own this narrative and stay with it. So I would wake up 15 years ago, and in the morning about 4 or 5 a.m. would start blogging, right? And writing my thoughts on a blog, blogger.com at the time, and would just write my thoughts initially. A year later, I launched the blog. 14 years later, we're still here. It became a magazine. It really launched the careers of lots of African designers and musicians, because once it started to really take off, the musicians were like, don't forget us. And the filmmakers were, don't forget us. So it started to be this whole platform that has really launched the careers and provided a lot of free marketing and promotions to a lot of design brands. And I did recognize some of the people here that sometimes will send me content for their clients as well from the PR side, among others. So that is the history of my intentional focus on trying to be a part of changing that bias in African fashion. What was interesting also in that background is that what ended up happening was a lot of the stakeholders that weren't even considering African fashion would tell me that when they were presenting for their fashion brands to different stakeholders for sponsorship, etc., and their investors would say, well, we don't know what you're talking about. What does it look like? And they would literally take images or cover magazines and show them saying, hey, there's already a platform, Lady Bro magazine, and it is what that looks like. And as a result would receive funding. I received so many testimonials about that. So it is good to be here. You're doing great work, and it's very important work. And I'm so glad that your organization is here. And I wish you all continued long success as you go along. So having sort of given you a background, let me just drop a few things. Fashion for me is about heritage. My maternal side of the family is all fashion. My grandfather was in fashion. My cousins are, some of them are designers as well. So it's personal as much as it is commercial as well. And I already gave you my background. And of course, Udochi read my background as well. So why is it important, coming from that standpoint, that we as Africans be concerned about protecting our intellectual property and fashion through fashion as a whole? One of the things you have to think about is it costs a lot of money to create intellectual property, period. It's just very time consuming and costs a lot of money to create, even when you're on the continent, creating the resources, the funding, among other things, to create the product particularly. And then once you create the product, it's sort of ridiculous that someone can take it and then just distribute it everywhere, reproduce and distribute it without any protection. So you do need protection for all of that labor and cost that goes into it. The second one is an identity issue, right? So going back to what I was saying about my identity here in the States, over on the continent, you don't want people taking your products and then presenting it, whether in the West or anywhere else, to be theirs when it's not, and getting a lot of kudos and monetizing that and making so much money and having intergenerational wealth that they leave for their children's children or businesses that they bail out all of your intellectual property. We don't want that. That's not the right result in a fair and just society. So thinking about the fact that it costs a lot to develop your IP. It also contributes to the national economy for every different African country or countries in general. If we could look at how the US or the UK or other Western countries have sort of built out their IP, we'll see that one of the reasons why they are successful nations is because of that contribution to that GDP. And so with African nations, we should be very, very interested and focused on doing that. And then the final reason why you want to most likely protect your intellectual property is it fosters creativity. If I put all this work and created intellectual property and it's great work and someone just immediately just is able to steal with no repercussions, it's going to make me feel disheartened and not want to go likely to go recreate my new or create new products and or services, but particularly new products that I want to put in the marketplace. So we want to foster creativity. We don't want our creatively intelligent people to just sit on the sideline and say, no, I'm not doing it again because I keep getting copied over and over again. All right, so having said that, let me talk about the cost and loss due to intellectual property infringement. There are no numbers that I was able to gather from the African side of things, but from the US reference in that, even despite the robust intellectual property regime that we have here in the US, there in 2018 there was report that over what it cost us was over $450 billion just in IP infringement alone. Can you imagine that? $450 billion. You can only imagine on the side of the African continent as well. Lots and lots of intellectual property stolen from artwork to music to fashion, and there are literally no repercussions. No one is really there to collect those or to be able to go into courts on the continent and here in the US to enforce those things, partly because the owners of those IPs are not even aware that those remedies are available for them to reach out to the lawyers, to reach out to the people that can help them with that protection. Having said that, let me now define how you protect your intellectual property by talking about four key vehicles that you can use to do that. The fourth one is not necessarily intellectual property in that real sense of the word, but it's usually referenced. So we'll start off with patents. Every time you deal with patents, you're talking about inventions, inventions of the mind that you create in a concrete form. So that's your design patents. And it's usually subdivided into utility design, which is more of the functional type of design. And then you do have also the design patent. And the design patents in the fashion context, we're talking ornamental design for the most part. And what it does with when you're talking about patent law and all of the intellectual property law I will discuss are essentially giving you the right, exclusive monopoly, the right to exclude everybody else, but have your IP to do whatever you want to do with it. Specifically, you have that monopoly to assign your intellectual property rights, so give it away forever and ever to someone else. Or if you don't do that, you have the right to also license it. So give it for a permitted, limited permission for someone to use it. And then the original rights still remain with you as the owner or the author of that particular intellectual property. In the US, utility patents last 20 years from the day that you file it, and it protects, again, the way an article is used and works. And then design patents are 14 years and protects from the day of from the issue date, protects the way an article looks. So design patents focus on the looks, utility focuses on how it works. Then there are trademarks. Trademarks are source identifiers. And what that does is, so I talked about Lady Brill. Lady Brill is a registered trademark, and what it does when you have a trademark, it essentially helps distinguish you as the source of a particular good from another. So it's a source identifier that distinguishes a good or service from another a good or service of a different company. And the reason why you want a trademark is you want to protect from the likelihood of confusion. So the trademark statutes, and I'll use Nigeria in this example just because it's the more prominent African country. But if you're from a different African country and you want to ask questions about your specific country, I'm happy to answer that as well. But for intended purposes, US and Nigeria are my reference point. So trademark law for the US, for the UK, Nigeria, and a few African countries' laws that I've had an opportunity to look at really focus on, we don't want to confuse the customers. We want to prevent what's called likelihood of confusion. We don't want mistakes. We don't want deceit. We don't want a consumer to think I'm getting Louis Vuitton, or I'm getting Diola Sego, or I'm getting Tiffany Amber, but it's actually not Tiffany Amber. It's a different brand trying to pretend that it is Tiffany Amber. And so that's what trademark law is all about, in the registration of it. Copyright is an interesting one as well. You will see copyright, trademark you'll see mostly in the fashion industry. Copyright you'll see mostly in film and music, even though these days in fashion, copyright is becoming more and more applicable. And the reason why you see more trademark in fashion versus copyright specific to designers is because in the US, for example, I don't know about other particular African laws. And on the Nigerian end, it's not per se quite clear how that particular law works. But on the US end, the idea is that we're not going to trademark and give you a monopoly as a design. I mean, we're not going to copyright and give you a monopoly over designs that are pretty much functional. If you say, for example, the silhouette of an outfit you create should be protected, that means we're all not going to wear clothes and walk around naked, and that's not going to happen. So it's very nuanced in terms of the kind of protection you can get from copyright in fashion. So if you actually create an interesting design pattern, for example, that's protected under copyright law. And that's also applicable actually in different countries, specifically for our intended purposes, Nigeria as well. South Africa has similar law, UK has similar law. So you're protected in that sense. But if you want to say in general, no, I want copyright protection for a particular silhouette, for a particular, you know, top or bottom, you're probably not going to get it because there's nothing per se unique about the creativity or the copyrighted work that you've created. If you go to the market, for example, buy someone else's fabric, cut it out, make it look good with a top or bottom or nice dress, and then you're like, oh my God, the other person copied me because they have the exact same fabric pattern. Well, you're not the owner of the fabric, right? And even if they cut it and design it the exact same way you did, you're not the owner of the fabric and the fabric design that is. And then you're also not the owner or exclusive monopoly owner of how we wear a top and a bottom. There's only so many ways you can design that. So with copyright, they're exclusive bundle of rights that you're given as a result of having a copyright, and that is the right to reproduce the work. So you can take it and make so many copies. You have the right to create derivative works. So you can take an existing work and create a remix of that work, for example. You can display the work, you can perform the work, among other rights that are given to you, and you can certainly distribute the work as well. All right, so let's go to something that comes up over and over again, and certainly in the African context, we can understand it. If you're like me, you probably spent a lot of time going to the markets with your parent, particularly your mother, or on the father's side, taking the fathers taking the sons to the markets where you see copying of all kinds of things, right? So there's what's called knockoffs. Knockoffs are basically reproduction of an exact copy of an original good, but you don't have any kind of logo or anything on it pretending to be what it's not. When you get to counterfeit, it's the exact same knockoff of an original good, but now you're having the logo of, let's use Diola Sego again. A logo is Diola Sego attached to it. So now if I come and I think a design is Diola Sego's, it's actually not, but it also has a trademark pretending essentially that it is her work. So that constitutes a counterfeit. And then, of course, I've already talked about trademark and copyright. And the way you get infringement is when anyone uses, especially as it relates to copyright and trademark and patents, when you have a situation where your work is used without your consent. So the author of the works someone else uses the work of the author without consent. How do we get copyright protection when we know that in the US, in Nigeria, in other parts, South Africa, UK, Kenya has similar laws. You have your trademark law, you have your copyright law, you have your patent law, you have your industrial design, which is basically your design patent that I was talking about. Specific to Nigeria, they call it that. And then there are other laws, criminal laws that can protect you there. And then there are international treaties. So if you're in Nigeria and someone in the US infringes on your work, what are the protections? Or if you're in Nigeria, what are the protections if someone locally infringes on your work? Number one, you want to ensure that you get with a lawyer to help you register your trademark. You also, if you have copyrighted works that you create, you want to ensure that you also register it. We're going to look at a case study, a very popular case study that's been talked about for a while to sort of illustrate that point. If you have an invention on the patent side, you want to make sure you have that protection. If there are criminal laws, which they are, to protect you, um, a good example is a lot of our Nollywood films that are infringed upon through piracy and all the other things that happen. And you see the law enforcement in Nigeria will go to market sometimes and just confiscate all the products and ensure that that copy, that infringement is no longer going on. So that's on the local end. On the international end, it becomes very, very interesting because if you have your specific country and it's not a signatory to certain international treaties, you may not be afforded that protection. However, if your country is a signatory to international treaties, then you will be afforded protection in the country, for example, that an infringement occurs. And we'll see how that plays out pretty soon. So what are some of the international treaties you should be aware of? You've got several. Let's start first with the Hague Treaty. Nigeria is not a signatory to the Hague Treaty, but essentially the Hague Treaty allows for protection for industrial designs. And what would happen is instead of having to file in different countries, you can file a single application with WIPO, World Intellectual Property Organization, and you receive protection in about 88 member countries, the US included. So that's for the Hague Treaty specific to industrial designs. And then you've got the Berne Convention. That's something that's talked about very often. And with the Berne Convention, essentially, again, you have that reciprocity. Nigeria is a signatory to the Berne Convention on a lot of other countries. So what happens is because Nigeria is a signatory to it, the Berne Convention deals with copyright protection. So essentially what would happen is you would have, if you were in Nigeria and someone infringes on your copyright in the US, unlike a domestic, so US citizen living in the US, you don't have to register your copyright in order to march into federal court and file a lawsuit against them for intellectual property infringement. If you're a US citizen based here in the US, you will have to register your work in order for you to be able to file a lawsuit in federal court. But because you're in Nigeria, Nigerian citizen, and someone in the US citizen has infringed upon your work, you don't have to wait to go file or register a register a copyright. You can immediately contact a lawyer locally here, let them know what's going on, and then that lawyer can help you with that infringement issue. Also, there's the WIPO Copyright Treaty that also deals with copyright protection. And essentially what it does, it expands the Berne Convention to cover digital works. So if you have works in the digital space and there's an infringement that happens, then the work is expanded. The rights are expanded to protect you there. Nigeria and the US are signatories to it. So again, you would get that protection. All right, so let's go to how you then, if you are over, and I'm pretty much wrapped up, and then we'll look at the case study of Ugo Monye to illustrate that, and I'll take your questions that you have. So what are your remedies if someone infringes on your intellectual property, right? Knowing first the importance of it, how you're creating it, the monetization of it, how much it costs you to even create it, market, promote, build a brand name. DLR Sego, Tiffany Amber, a lot of our more established designers, a lot of designers from South Africa. When I started Lady Brill magazine back in the days on YouTube, there was only one YouTube video period that had anything to do with African fashion, and it was South Africa Fashion Week video. And it wasn't even a fashion show. It was a performer dancing on the runway for during Fashion Week. But over time now we see obviously so many different fashion weeks across the continent, and all of that stuff is streamed, live streamed, or you could watch a replay on YouTube. So if someone copies or infringes on your particular design, what are your remedies? Or infringes on your trademarks, what are your remedies? In the US, assuming that happens here in the US, and you're over back home in Nigeria or anywhere on the continent, South Africa, etc., what you can do is have your local attorney in Nigeria or wherever you may be liaison with your attorney here in the US, or you can directly contact that attorney in the US. It's all up to you. But the first thing that will start is that attorney, the very first leg of trying to make that stop is that attorney will send what's called a cease and desist letter. So the infringing organization will get a letter, let's say it was from my firm, will say, hey, you know what? I have a client. The client is saying you've infringed on their intellectual property. I'm gonna need you to stop doing it. I'm just keeping it short and sweet in simple terms. I'm gonna need you to stop doing it, or else it's about to be war on this thing. And of course, the letter is very well crafted. The facts are laid out. The legal basis for it are laid out. The evidence to support showing that infringement are laid out. And if you use it well, depending on the lawyer, if you use it well, it hopefully should help stop the infringement, and parties come together to want to work it out. Sometimes people, the infringing party may think, okay, fine, especially for lawyers back in Nigeria or other countries that send us letters, the people overseas here are like, okay, well, make me stop, right? Because if I'm going to stop that infringement, it's already out in the marketplace. There's so many copies. Let's say it's music. That's just a lot of money I'm going to have to give to you. And then the accounting and the audit about all of that money. So unless you have someone on the ground to actually take the case and say, hey, you know what? You're going to have to stop, and then you're going to have to give the accounting of the royalties, and then I'm going to file an injunction and make you stop, and make the court make you stop, take that thing off the market. Generally, you will have sort of like, whatever, I know you can't afford the cost of a lawyer locally here, so it's not going to happen. So there's a cease and desist letter that can be sent locally here through your lawyer. There's the mediation. So mediation it's informal, where all parties get together and try to talk things out and work things out and solve the issue without having the interjection of a court involved. Then there's arbitration, which is sort of like a mini trial that happens, if you will, a quasi judicial trial. And usually you don't have a judge as an arbitrator, although you can have retired judges that have their arbitration practice. And basically, informally, you have the two parties come, they present their sides, the plaintiff, the defendant, or, they present all of their evidence, et cetera, and then the arbitrator makes a decision. That can be a binding decision or non-binding. If it's binding, what you get is what you get. You don't get the ability to then take it to a regular court to try to sue again. If it's non-binding, you can always go and do that. And then in the US, something interesting has happened over the past few years, which is the launch of small claims copyright court, which allows those whose intellectual property has been infringed up to $30,000. So they can take that to small claims and have that adjudicated. The nice thing about it is you don't generally need an attorney in small claims. And if you're, for example, an African creative where your intellectual property, specifically copyright, has been infringed upon, the cost of going to small claims is not as high in order for you to go. It's very minimal. And the turnaround time, 3 months to 6 months maximum. I'm just saying that's pushing it. Generally within weeks, you have a quick turnaround time, 30 days, frankly speaking, where you have a decision on the small claim side of things. And again, the maximum recovery is 30,000. And then if you're talking about litigation trial, the part I was talking about, that can start anywhere from 65, 70,000 above to hundreds of thousands and millions of dollars to deal with that particular infringement issue. So having said that, let me talk about the case study of Ugomonye, or do you want to ask questions and then I will take it from there? Udochi, would you like me to do that, or do you want me to talk about that case study?
I think maybe the case study first, just to
Okay.
illustrate a bit more, and then we can take
So
Q and
let's talk
A's.
about Ugo Monye and versus Coming to America producers. And in that particular case, I think in 2017, if you follow the African entertainment space, you're well aware of Ebuka. I think, how do you say Ebuka's last name? Uchendu, I believe. And he is actually a former lawyer, doesn't practice, or a lawyer doesn't practice anymore, but is a host of several different media shows. And he also is a fashion personality, or became a fashion personality because particularly of this Ugomanya design. So Ugomanya dressed Ebuka to Banky W and Adesua Itomi, so musician and filmmaker, actress, were getting married. And Ebuka was one of their guests, a friend and guest. And he was dressed in this beautiful burgundy Ugomonye design, which had what Ugomonye calls a real design and was sort of based off the kimono, the Japanese kimono style. And in addition, Ugomonye did something different, more modern and cosmopolitan with the Nigerian traditional wear that men wear. So the agbada, he made it very cosmopolitan and contemporary with the design. So back to Coming to America, 33 years later, they decide we're going to have Coming to America 2. Everyone's excited. The work finally publishes, is distributed everywhere. And according to Ugomonye, he sees and comes to find out that the customer that was hired by the production team decided that she was going to commission local Nigerian tailors to create the exact same real design that Ugomonye has. And so that was created. And so in the Coming to America movie, you can actually see some of the actors dressed in the exact same Ebuka type design. So Ugomonye's design, the rendition. Ugomonye puts out a release, a press statement saying, I never authorized this. This is an infringement of several laws specific to Nigeria, trademark acts, patent acts, and copyright, because under all those three acts, I went ahead and registered the work. Therefore, I'm asking that you cease and desist. And then he also mentioned that he's working all that through his lawyers. Of course, that became a viral thing because people are always curious, especially David and Goliath looking type situations. And especially when you have the constant recurring issue of alleged copyright infringement, alleged appropriation of culture, because that can be a very interesting conversation that has so many complex layers, including those who claim it. Because, for example, when you're talking about the kimono design, well, the kimono design rendition and inspiration arguably comes from the Japanese people. Should they be suing you for the infringement of that? Who knows, right? And then what's the specific uniqueness of the design that you created that makes it more yours, right? The Agbada definitely, but when you start looking at those different layers, it gets very interesting on that cultural appropriation type of discussion. Sometimes it's very blatant, you can see it. And then other times, if you're drawing different inspiration left and right, should we say then that you are infringing on other countries' IP rights and their folklore rights? That's always a question to ask. So that's why I put alleged, because it's never quite clear cut. When you're dealing with the law, you have to go into court and may the best man win. So if you decide to go and you can't resolve the issue. So anyway, it's gone everywhere. It's gone viral. And the question has been, and a lot more people really concerned about, how do we protect our intellectual property in light of some of those types of issues? But this is not the first time we've seen that. Again, going back to 14 years and over time of writing and having writers cover this issue. One of the things I started to see on the Western runway was the African inspired. We've seen all kinds of African inspired. And I remember when at some point you started to have American designers and Western designers as a whole have Ankara fabric patterns that they would create and, into interesting and fun silhouettes. And then, send those models down. And what happened during that era was you had so many African designers saying, oh my God, you're copying. And I did a quick research only to find out that the Ankara fabrics don't even belong to our region. They belong to the Dutch people. And the Dutch people for decades have been on the continent and making so much money, but we don't own the designs they create. Vlisco designs that are created in the Dutch print and wax, distributed everywhere. But local to us, for example, in Nigeria, our adires, for example, we own that. The designs we use for ashoke, or if you look at Ghana and the Ghana Kente clothing and all the different designs that are on that, we own that, but we don't own the Dutch Ankara fabrics. And that was sort of a retooling of the mind. A lot of people got educated on that. Subsequently, there was another case out of Ethiopia. The Ethiopian government actually moved forward with filing a suit, if memory serves me right, where you had the designer Mark Bauer, who infringed on the cultural designs that you would see on the clothing that the Ethiopian woman wears, the white, beautiful fabric, garment they wear, and then there's always a design at the neck side of it, intricate designs. Anyway, Magbaro had the exact same thing on the runway and called it African inspired, or similar thing on the runway, called it African inspired. And the government there said, no, it's not going to be that kind of party. You need to stop. And if memory serves me right, they either threatened or filed a suit. I don't know what became of that situation. And then we've certainly seen it with the Maasai people and the Maasai tribe over and over again. We'll see once upon a time, or once in a while, we'll see, Western designers having models walk down the runway in Maasai designs and try to make it seem like it's something new or innovative. And in such specific instances, the government is responsible for protecting the folklore and just traditional cultures and designs of its people. And if it's not actively doing that and not actively registering with certain specific international treaties, and it's not specifically being a signatory to those treaties, then it really leaves its people exposed. And it just is what it is until the people put that pressure on the government to step it up and do what needs to be done. So I'm going to wrap it up there. Any questions, please feel free to ask. Happy to answer.
Thank you so much, Uduak. So if you have any questions, feel free to unmute yourself and just ask your question. Or you can also type it into the chat. I think I saw a comment actually on the chat. Let me see if I can pull it up. So from Jennifer, it says, is it a bad idea to integrate kimonos, Scottish tweeds, African kente, Chinese tuxedo, Indian sari in a design when you are not from that country?
No, not at all. It's not a bad idea. You're more than welcome to integrate that. The issue is intellectual property. If you claim that you've been infringed upon, then you're taking other people's established copyrighted work and you're creating a derivative work off of that, because everybody, all those different people own their IPs in the different, so the Japanese kimono, etc. If you're creating all that, if you're taking all that to create a new work out of that, like it's all integrated into it, then if you do claim, oh, well, you infringed on my IP, which particular part of the IP is yours? It's the completely separate new work you are able to create, as opposed to all of this different people's IPs that you've taken on to create. So let's use it in a music context. If they already have pre-existing musical works and you take that and you sample that work and create something, a whole new beat from it, that music, yes, it's unique to you and the way you've created it, but it doesn't change the fact that the pre-existing copyrighted work belongs to whoever the original creators are. And you do need permission for that. So that's the question on how that plays out, especially in the context of international law, because if all those different countries are signatories to the Berne Convention, for example, and your country is a signatory to the Berne Convention, then you are infringing on the IP rights of all those different countries. To create yours, you might not be pursued or anyone come after you, but if you go now and you want to come after people for what you're creating, maybe in your country, that might not be too much of an issue per se, but it sort of begs the question of, okay, well, where does that really, is it really your full copyrighted creativity? So that's what I was addressing when I was talking about that Ugomonye uniqueness to it.
Thank you so much. So I actually had a couple of questions
Sure.
while people are still thinking. So the first question I had goes back to when you talked about the different ways that you can protect your work,
Mhm.
patents, trademarks, copyrights.
Mhm.
So in fashion, how do you know which one to use? How do you know what you can patent, what you can put a trademark on, and what you can copyright?
You consult with your lawyer to help you out because for the most part, a lot of designers are not going to know those kinds of things generally. But to be clear, if you have an idea, right, the idea is not protected. The expression of the idea once you create the work is what will be protected. But how you know that is if you're like, oh, I'm concerned that if I create something, someone's going to steal it from me, etc., then you should consult with a lawyer at that preliminary base to help you clarify what the rights are, and that way you understand moving forward in terms of that. Now if you're in some remote location and you have no idea what that is, that's probably not going to be your concern initially as you're creating things anyways.
Okay. My second question was this one, the question in the chat. So I'll
Yes.
take that after I ask this one. My
Okay.
second question was you mentioned some of the conventions like WIPO and the Burns Convention.
Hmm.
Is there any way you can go to find out if your country is a signatory to some of these conventions?
Yeah, just simply Google it.
Okay.
Google it and you should be able to pull up that information, or go to the WIPO website. But I would Google it because the WIPO website might actually be a little too overwhelming if you don't know where to
Okay.
search.
Okay.
So if you Google it, you should be able
And
to.
WIPO is WIPO. Is that
Yeah, World
correct? Okay.
Intellectual Property Organization.
Okay, great. So the second question, I think, or I'm not sure if it's a comment, it says upcycling has become popular. When an item is upcycled, do we keep the old label and add ours, or should we remove the old label?
I mean, it's 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 hard to advise on that, right? Because again, when you I'm not sure how to particularly respond to that. Can you clarify a bit more? When an item is upcycled, do we keep the old label and add ours? What specifically are you trying to get at, Jennifer? Is that Jennifer that wrote that?
Yes, from Jennifer again.
Mhm.
Okay, hi, thank you
Hi,
very much.
Jennifer.
All
Mhm.
right, so my baby might scream. Upcycling is being very popular in Africa because we
Yeah.
have landfill that we're protecting. And when we upcycle, which means that we add our own style, our own creativity to it, and then put it, in my case, I've put it on the runway. I've always had the question, do I keep the label that was there when it was picked up from the ground? Do I add my own label, or what do I do? And I haven't actually found the answer to that. And upcycling is becoming hugely popular. So I don't think there's anybody who, I haven't found anyone who can give me an answer to what
Yeah,
does what
it's a
do.
very interesting question, and evolving one too, because you're you're in the trademark space, right? Right? Because you're talking about that logo that you're taking from the particular clothing and then deciding that you want to just use the clothing itself. But I think in terms of infringement, this is obviously not legal advice. This is just sort of talking it out on maybe how the analysis would play. You're not using that logo to create the a good and service that's very similar from similar like the other brand that initially had the initial construction of the clothing, right? So let's say it's Louis Vuitton. You're not taking the Louis Vuitton clothing with the Louis Vuitton trademark and then presenting something exactly similar with your own trademark, which would be counterfeiting of that good. You're not doing that. You're essentially looking more using the functionality of the clothing itself to create your own silhouettes and clothing, and then put in all your patterns and designs on it. So to me, that should not create any issue on that based on how you've explained it.
So we keep the two logos or one logo.
This is not legal advice. I cannot advise you on that. And I can't say keep two or one logo. You shouldn't be having the logo of anybody that is not yours incorporated into your clothing design. You see what I'm saying? The,
Yes, of course. So
the
we
two
cut it
things,
off.
the two things you have to be concerned about: the trademark infringement and the copyright infringement. So if you're removing the logo on a clothing and turning it into something else, there are really no issues there on trademark infringement, right? Because the trademark infringement has to do with the logo, the symbol, the design, as opposed to the silhouette or functionality of a clothing material. So you're just saying, I'm taking clothing that I have, I'm cutting it into different things and adding and doing something else, remixing it with something else. That's completely different than the logo itself, using the logo and creating an exact replica of what's being created already, and then slapping your own or that logo or your own logo, pretending to be the person, or pretending to be Louis Vuitton, for example, or doing something else that infringes on that particular logo. Are you
Thank you.
understanding that, Jennifer?
Yes, I do. I think a lot of people would like to watch this over. And if there's a legal way connection, sorry. Sorry.
It's always very case specific, right? So you have to have an attorney consult with you on that. But based on the facts that you've shared, I don't see any issue as to the trademark issue, right? You haven't explained on the clothing side whose fabric patterns or designs you're using. But generally, if it's the one you find in the marketplace, then that's not an issue generally either. All right, Udochi?
Any other questions? Feel free to just unmute yourself and ask a question. We'll take maybe one or two more. Okay, so if no questions, I'll ask my final one.
Sure.
So my question is, if you're looking to find a lawyer that can work with you in terms of IP protection, what do you recommend that individuals look for to make sure that they're finding somebody who's qualified to really work with them?
Fashion law is still emerging, and at some point we really thought it was going to take off, but it hasn't taken off the way we, as some of the few fashion law trailblazers in the States, thought it would. But they're building some momentums on the continent. If you're on the continent, that's a tough one, because even me, I'm not aware of that many fashion lawyers with the experience on the continent per se. But I'm sure if you look at your local, so every country, so far so good that most of the key leading countries, let me put it that way, in the African market do have what they call a bar association. The bar association is an organization that, for the most part, lawyers belong to, and depending on the bar association, might even regulate the practice of law. So if you contact them, in Nigeria, for example, there's the Nigerian Bar Association. They will reference you to lawyers that they think would be able to help you. And there might be maybe a fashion lawyer there. But there are not many fashion lawyers, but you should, depending on where you are, look for a lawyer that has experience with the fashion business. It's always important because they can then issue spot and not waste too much time on things that, end up costing you too much money. So if you come, for example, I'll use me, I have experience in the fashion industry. Let's say you are in the US and your matter is a fashion law related matter. I'm not going to try to figure out how the whole, supply chain or manufacturing works, or, how a designer creates a design and the entire value chain process, because I already know that. Not only do I know it from the back end, but as a model walking down the runway as well and seeing a lot of that. So it's easy to go straight to the issues and what the legal issues are there. So you want a lawyer that at least has some sort of experience in the creative industry, even if it's not specifically fashion, but preferably fashion. You want a lawyer that obviously is competent. You want a lawyer that that asks the questions, will do the research, and if the lawyer doesn't know, can liaison with others who have the expertise. So if you have someone local in Nigeria, for example, and maybe they don't have the fashion background, but they know that they need to go, liaison with somebody else, whether in a different country, to consult with that person to help them, or refer that case out if it happens to be in the local jurisdiction where the other lawyer is that has a fashion law experience. So that's how I would answer that question. You could certainly also Google to find out fashion lawyers as well. But if you're on the continent, then you'll be hard pressed to find fashion lawyers that are doing that. And then there are few folks trying to do fashion law, but just recent law graduates. That one just recently got licensed. And even then, the reference point is still us, the international lawyers. And that's specific to Nigeria. So if you Google also, you might be able to find fashion law firms on the continent. In the US, if you Google, you'll find a few fashion lawyers here in the US that can assist you. The final alternative is my colleague out of New York, Fashion Law Institute. It's still focused on US law, but it's a reference point to also look at. Maybe they might be able to help you with referring you out if there are other lawyers they might know outside of the US.
Great. Well, thank you so much, Uduak. This was
I prefer
a
to be
great
called Miss Uduak, actually.
Okay, yes.
I did say it, yeah.
Thank you so much, Ms. Uduak. This was a great conversation. Thank you for your presentation. And I'm so happy that we have it recorded so that we can have others also watch it in future and also take away something from it.
Absolutely, my pleasure.
Thank you. So I'm just going to share, as we come to the close of this session, I'm just going to share quickly a slide so that you can see how you can stay in contact with us at BAF, Bias in African Fashion. Again, we are an organization that's looking to really address issues of bias and prejudice in African fashion. And the topic that we're talking about today, copyright protection or IP protection, is one area that we found that has allowed some abuse for those in our industry. So that's why we're having this conversation today. So please register to join our email list. You can see the link there to join, bit.ly/BAF mail. You can also follow us on social media. We are on Instagram, Facebook, and LinkedIn at Bias in African Fashion, and on Twitter at Bias African Fashion. Once you follow us, you'll be able to know when we have more sessions and events such as this coming up. We will be having a second part to this later on this week. That will be on Clubhouse. That will be just a chance to allow more discussion among those in the industry to see how we can find solutions as an industry to the problem of copying of work by African creatives, African fashion creatives. So that the information for that will be shared on our social media in coming days so that you can be aware of how you can join us for that segment. Also, we've been having regional chats, talking to people in different parts of the continent to understand again what their experience has been in the industry. We have the chat for East Africa coming up this week as well. That will be on Thursday as well. It will be at 4 p.m. East African time. Again, if you follow us on social media, you'll be able to get the details on how to register and to be a part of that. So I just want to say thank you again to everybody for joining us today. Thank you to Ms. Uduak for being here.
Udochi, just a quick one, if you don't mind, so I can share how people can reach me if they're interested in reaching me as well.
Definitely. Go ahead.
Thank you. So for anyone interested, please, you can reach me at Fashion ENT Law, Fashion ENT, fashionentlaw.com. And that's where you can contact me if you have follow-up questions. I'm also available on all social media handles with Miss Uduak, and that's at the @ MSUDUAK at Miss Uduak on Twitter, Instagram, everywhere. Thank you.
Great, thank you so much. And so thank you again to everyone for joining us. We look forward to having you at future events and to having you engage with us more as we do this work that we're looking to do. Take care and have a great rest of the day. Bye-bye.
Bye, everybody.
Thank you.
Bye.